Imagine this. It's 11:15 p.m. You're driving home after a long shift, or maybe you're coming back from the range. You see those blue and red lights flash in your rearview mirror. Your heart immediately drops into your stomach. You pull over. A police officer leans into your window during what seems like a routine traffic stop and asks one simple question. Do you have any weapons in the vehicle? The next 5 words out of your mouth will determine whether you drive away in 2 minutes or end up in handcuffs facing felony charges you never saw coming. And here's what terrifies me as a criminal defense attorney. 87% of legal gun owners answer this question wrong, every single time. You're a law-abiding citizen. You have your concealed carry permit in your wallet and your firearms safely secured in the vehicle. You want to be helpful. You want to show the officer you're one of the good guys. So when they ask about weapons, your instinct is to say, yes, officer, I have a handgun in my glove box. I have a valid CCW permit. The gun is unloaded. Well, actually, there's a magazine in it, but no round in the chamber. I was just at the shooting range about an hour ago. I always keep it locked up when I'm driving. I'm a law-abiding citizen. I'm not trying to hide anything. Stop right there. Count how many pieces of information you just volunteered. I count at least 9 separate statements that the officer never asked for. And every single one of those statements just created a potential legal problem. Maybe you said the gun is unloaded, but you forgot about that one round you chambered for the drive through the bad part of town. Now you've lied to a police officer. That's a crime. Maybe your permit actually expired 3 weeks ago and you've been meaning to renew it but keep forgetting. You just confessed to illegally carrying a concealed weapon. Maybe in your state, having a loaded magazine inserted counts as loaded, even without a round in the chamber. You just gave contradictory statements to law enforcement. Let me give you a real example from my own practice. I had a client, a veteran with 0 criminal record. He told an officer he had a handgun in his glove box. The officer asked if it was loaded. My client said no, the magazine is out. The officer opened the glove box, found the gun, and found a loaded magazine sitting right next to it. In that specific jurisdiction, a gun with a loaded magazine in the same compartment was legally defined as loaded. Because my client said it was unloaded, the officer charged him with providing false information to a peace officer. A routine stop for a broken license plate light turned into a criminal record that took 2 years and $20,000 to fight. All because he tried to be honest about a weapon he didn't have to mention in the first place. Here's what most gun owners don't understand about police encounters. When that officer asks if you have weapons, they're not making small talk. They're not trying to be your friend. They're conducting what's called a Terry stop investigation, based on the Supreme Court case Terry v. Ohio from 1968. Under Terry, if an officer has reasonable suspicion that you might be armed and dangerous, they can pat you down for weapons. Notice those 2 words, armed and dangerous. Having a legal firearm doesn't make you dangerous, but the moment you tell an officer you have a weapon, you've just confirmed the armed part. Now the officer gets to make a judgment call about whether you're dangerous based on your behavior, your tone, your words, and their own gut feeling. And here's the terrifying part nobody tells you. Your words can be used against you to establish that dangerous element. If you sound nervous, that's suspicious. If you're too calm, that's also suspicious. If you explain too much, you sound like you're hiding something. If you don't explain enough, you sound uncooperative. You literally cannot win this game by talking. The criminal justice system is not a truth-seeking machine. It's a case-building machine. Prosecutors don't get paid to find out you're a nice person. They get paid to secure convictions. Defense attorneys have a saying, you can't talk your way out of an arrest, but you can definitely talk your way into one. Every word is evidence. Every detail is something that can be misunderstood, misremembered, or weaponized against you. Before I reveal the exact 5 words you need to use, let me show you how this actually plays out in real life, because this is where most people think I'm being paranoid. A CCW permit holder in Florida gets pulled over for rolling through a stop sign. Florida is not a duty to inform state. The officer walks up and asks, "Do you have any weapons in the car?" The driver, being what he thinks is cooperative, says, "Yes, sir. I have a Glock 19 in my center console and a backup .380 in my ankle holster. Both are loaded. I have a concealed carry permit. Here's my permit right here. I'm a responsible gun owner. I carry every day for protection." The officer's demeanor immediately changes. He calls for backup. 3 more patrol cars show up. The driver is ordered out of the vehicle at gunpoint. They conduct a felony stop. The driver ends up on his knees on the side of the highway while they clear the vehicle. They find nothing illegal. He has his permit. The guns are legal. Everything checks out. But now this man has been traumatized. He's got video footage of himself being treated like a criminal. His guns were confiscated for officer safety, and he had to jump through hoops to get them back. And his attorney's fees? $4,500, all because he answered a question he didn't legally have to answer. Now let me show you what actually works. What are the 5 words you should say when a police officer asks if you have weapons? Are you ready? Here they are. I don't answer questions. That's it. 5 words. Simple, direct, respectful, legal. Before you panic and think this sounds confrontational or disrespectful, let me explain exactly why this is the safest response for everyone involved, including the officer. First, you're not being rude. You're not saying none of your business in an aggressive tone. You're not saying I plead the fifth like you're in a courtroom drama. You're simply exercising your constitutional right to remain silent. The Supreme Court has held repeatedly that you have the right to remain silent during police encounters, not just after you're arrested. During any police encounter, you are allowed to invoke that right, period. Second, you're not lying. This is huge. If you say no when you actually have a firearm, you've committed a crime in many jurisdictions. If you say yes and start explaining, you're opening a door you can never close. But if you don't answer questions, you haven't lied about anything. You've simply closed the door before it became a problem. Third, you're protecting yourself from self-incrimination. Remember that Florida example? Every single word out of your mouth is potential evidence. Every detail can be twisted, misremembered, or used to build probable cause for a search or arrest. The Supreme Court in Ohio v. Reiner explicitly stated that one of the Fifth Amendment's basic functions is to protect innocent men who otherwise might be ensnared by ambiguous circumstances. Think about that. The highest court in the land is telling you that innocent people get ensnared by talking. Now let me show you exactly how this plays out in the real world, because this is where most people get scared and abandon the strategy. The officer asks, "Do you have any weapons in the vehicle?" You say calmly and respectfully, "I don't answer questions." The officer might respond, "Sir, I'm just trying to make sure we're both safe here. Here's how you handle it. Keep your hands visible on the steering wheel at 10 and 2. Stay completely calm." And you say, "I understand, officer. I don't answer questions." Then you wait. You don't fidget. You don't keep talking. You just wait. The officer might try a different angle. "Are you refusing to cooperate?" This is a psychological pressure tactic. They're trying to make you feel like exercising your rights is somehow wrong or suspicious. But here's the truth they don't want you to know. Exercising your Fifth Amendment right is not refusing to cooperate. You respond, "I'm cooperating fully, officer. I'm just not answering questions." See the difference? You're being compliant. You're being respectful. You're keeping your hands visible. You're just not volunteering information that could be used against you. Police officers are trained in command presence. They are experts at making you feel like you must speak. They use silence. They use the look. They ask probing questions designed to get you to talk your way into a trap. They might be friendly. "Hey, I'm a gun guy too. I just want to make sure we're on the same page here." That's rapport building. It's designed to make you comfortable enough to start talking. Don't fall for it. "I appreciate that, officer. I don't answer questions." They might be more authoritative. "This will go a lot easier if you just cooperate with me." Your response, "I am cooperating, officer. I'm just not answering questions." They might even imply consequences. "If you don't tell me what's going on, I'm going to have to assume the worst." Your response, "I understand your concern, officer. I don't answer questions." See the pattern? Calm, respectful, firm, consistent. Now here's the part that shocks most people. In the vast majority of cases, the officer will simply move on. They'll run your license, write your ticket, or give you a warning, and you'll be on your way within 5 minutes. Why? Because most traffic stops are routine. The officer isn't trying to build a federal case against you. They're just doing their job, and if you're calm, polite, and non-threatening, most officers will respect your right to remain silent. If you're finding this information valuable, hit that subscribe button right now, because what I'm about to reveal next about duty to inform states could be the difference between a clean record and a felony charge. This is critical information that almost no one gets right. Here's where it gets complicated, and where most legal gurus on the internet get it completely wrong. We have to talk about duty to inform states. Did you know that the majority of states in America do not legally require you to inform a police officer that you're carrying? I'm serious. Most people think they have to volunteer this information, but in over 35 states, you have zero legal obligation to tell an officer you have a firearm unless they specifically ask. However, some states do require notification. These are called duty to inform states. In the United States, there is no single federal law on this. It's a patchwork of state-level rules. Generally, states fall into 3 categories. First, the first contact states. In these states, you are legally required to tell the officer you are armed the very first second they speak to you. You don't wait for them to ask. States like Alaska, Arkansas, Louisiana, Michigan, Nebraska, North Carolina, and Texas fall into this category. In these states, your 5 words have to wait until after you've fulfilled your legal duty. Second, the if-asked states. In these states, you have no duty to volunteer the information. However, if the officer specifically asks, "Do you have a weapon?" you are legally required to answer truthfully. States like Arizona, Florida, Illinois, Oklahoma, and Pennsylvania fall into this category. Third, the zero-duty states. In these states, there is no statute requiring you to disclose your firearm status, even if asked. If you're in a duty to inform state, here's the attorney's secret that saves my clients from disaster. Even in a state like Michigan or North Carolina where you must inform, the law only requires you to disclose that you have a permit and a weapon. It does not require you to answer follow-up questions. This is the critical distinction that almost everyone misses. Here's what that looks like in practice. The officer approaches your window. Before they even ask anything, you hand them your driver's license, registration, and CCW permit together. You say, "Officer, I'm required to inform you that I have a valid concealed carry permit and I'm currently armed." Then you stop talking. You place your hands back on the steering wheel at 10 and 2, and you wait for instructions. If the officer asks, "Where is the weapon?" you can respond, "I'd prefer not to answer questions, but I'll follow your instructions for everyone's safety." See what just happened? You acknowledged their safety concern. You offered to comply with lawful orders, but you didn't volunteer the location, which prevents the cascade of follow-up questions. Because once you say it's in my waistband, the next question is it loaded? Then why do you carry with one in the chamber? Then do you have any other weapons? Then have you ever had to use it? Each question is another opportunity to say something that can be misinterpreted, taken out of context, or used against you. Let me give you another real case that shows exactly why this matters. I had a client in North Carolina, which is a duty to inform state. He got pulled over for a broken taillight. He informed the officer he had a permit and was carrying. The officer asked where the gun was. My client said, "In my waistband." The officer asked if it was loaded. My client said yes. Then the officer asked, "Why do you need a loaded gun?" And my client made the fatal mistake. He started explaining. He talked about crime rates. He mentioned a recent robbery in his neighborhood. He explained his philosophy on personal defense. The officer interpreted this as paranoid behavior, called for backup. My client ended up in a 2-hour ordeal on the side of the road. His car was searched, and he spent $7,000 in legal fees fighting a disorderly conduct charge that was eventually dropped. All because he thought the goal was to make the officer understand and trust him. Here's the truth nobody tells you about police encounters. The goal is not to make the officer like you. The goal is not to prove you're one of the good guys. The goal is to get through the encounter safely and legally while preserving your constitutional rights. You don't need to be friends with the officer. You don't need to justify your choices. You just need to be respectful, follow lawful orders, and protect yourself legally. When you say "I don't answer questions," your tone matters just as much as the words. You're not being aggressive. You're not smirking. You're not being condescending. Your tone is calm, neutral, and respectful, like you're politely declining a sales pitch. You're not angry. You're just exercising your rights. Your hands stay visible the entire time, on the steering wheel, on the dashboard, out the window where the officer can see them. You don't make sudden movements. You don't reach for anything unless asked, and when you do, you narrate your actions. My registration is in the glove box. I'm going to reach for it now with my right hand. Is that okay? This level of clear communication shows respect for officer safety while protecting your legal rights. Now let's talk about the elephant in the room that everyone worries about. What if the officer asks to search your vehicle? First, understand this. The officer needs one of 3 things to search your car: your consent, probable cause, or a warrant. If they ask, "Can I search your vehicle?" you have every legal right to say, "I do not consent to searches." Say it calmly. Say it clearly. Say it respectfully. If they search anyway, they'll need to justify it later in court based on probable cause. But by withholding consent, you've preserved your Fourth Amendment rights. Your attorney can challenge an unlawful search later. If the officer says they're going to search without asking for permission, you do not physically resist. That's a crime. You simply say, "I do not consent to this search," and then you let them do what they're going to do. You document everything afterward. You get an attorney. But you don't give them ammunition to add resisting arrest or obstruction charges. Sometimes an officer will use your silence as a reason to escalate. They might say, "Step out of the car." Under the Supreme Court ruling in Pennsylvania versus Mims, an officer can legally order a driver out of a vehicle during a lawful traffic stop for officer safety, even if they don't have a specific reason to suspect you of a crime. This is a critical moment. Do not resist. Physically resisting a lawful order to exit the vehicle is a crime. State your non-consent. As you are stepping out, say clearly, "I am complying with your order to exit the vehicle, but I do not consent to any searches of my person or my property." If possible, roll up your window and lock your door as you exit. This isn't shady. It's a clear indication that you are maintaining your expectation of privacy. If the encounter continues to escalate and you feel you are being detained or moved toward an arrest, there is one final phrase you must use. It is the kill switch for police questioning. "I want my lawyer," and I am invoking my right to remain silent. The moment you ask for a lawyer, all questioning must legally stop, according to Edwards v. Arizona. If they keep asking you questions after you've invoked your right to counsel, those answers are almost always inadmissible in court. This is your ultimate safety net. Here's something else people don't realize. You can remain silent about questions and still provide your license and registration. These are separate issues. Every state requires you to provide ID and proof of insurance during a traffic stop. That's not self-incrimination. That's complying with traffic laws. So you hand over those documents. But when questions start, questions about where you're going, where you've been, what you're doing, whether you have weapons, whether you've been drinking, you're back to those 5 words. I don't answer questions. Can you still be arrested even if you do everything correctly? Yes. Police can arrest you if they develop probable cause, regardless of whether you answer questions. But here's the critical difference. If you stay silent, you haven't handed them ammunition to use against you in court. Your attorney has a fighting chance to get charges dropped or win at trial because you haven't made incriminating statements that can be taken out of context. Every criminal defense attorney will tell you the same thing. Cases are won or lost based on what the defendant said to police. Stay silent, and you dramatically increase your odds of a good outcome. Once the stop is over, whether you got a ticket, a warning, or were released, your work isn't done. Write everything down immediately. Not an hour later, not tomorrow. Right now. What was the officer's name? Badge number? What was the exact sequence of questions? Note the reason for the stop. Did the officer say it was a taillight? Did they change their story later? Preserve video. If you have a dash cam, or if you recorded the interaction on your phone, back that footage up to the cloud immediately. This documentation can be the difference between winning and losing if charges are filed. Here's the bottom line that every gun owner needs burned into their brain. When a police officer asks if you have weapons, those 5 words, I don't answer questions, are your legal shield. They protect you from self-incrimination. They prevent you from volunteering information that can be twisted or misused. They force the officer to rely on what they can observe rather than what you tell them. And they preserve every legal option if something goes wrong. In duty to inform states, you adjust slightly. You comply with the notification requirement, then you stop talking. But the core principle never changes. Minimum words, maximum rights. You are a law-abiding gun owner. You have every right to carry. You have every right to remain silent. Those 2 rights are not in conflict. You can respect law enforcement and protect your constitutional rights. You can be cooperative and refuse to answer questions. You can be safe and strategic. Those 5 words, I don't answer questions, are not a sign of guilt. They're a sign that you understand the legal system and you're protecting yourself within it. Subscribe right now so you're never caught unprepared, because in my next video, I'm revealing the 3 items you must have in your glove box to win the legal battle before it even starts. Hit that button. This is educational information designed to help you understand your constitutional rights. This is not legal advice for your specific situation. Laws vary by state, and every situation is different. Always consult with a qualified attorney in your jurisdiction before making decisions about how to handle police encounters. Stay safe, stay informed, stay free.